General Register. Number 177,597 July 16, 2008. By Sandra S. A. Sema, Petitioner. Versus. Commission on Elections and Didagen P. Dilangalen, Respondents. General Register. Number 178,628. Perfecto F. Marquez, Petitioner. Versus. Commission on Elections, Respondent. The case. These consolidated petitions seek to annul Resolution Number 7902, dated the 10th of May 2007, of the Commission on Elections treating Cotabato City as part of the Legislative District of the Province of Sharif Kabun Suan. The facts. The ordinance appended to the 1987 Constitution apportioned 2 legislative districts for the province of Maguindanao. The first legislative district consists of Cotabato City and 8 municipalities. Maguindanao forms part of the Autonomous Region in Muslim Mindanao, created under its Organic Act, Republic Act 6734, as amended by Republic Act 9054. Although under the ordinance, Cotabato City forms part of Maguindanao's first legislative district, it is not part of the Autonomous Region in Muslim Mindanao but of Region 12, having voted against its inclusion in the Autonomous Region in Muslim Mindanao in the plebiscite held in November 1989. On the 28th of August 2006, the Autonomous Region in Muslim Mindanao's legislature, the Autonomous Region in Muslim Mindanao Regional Assembly, exercising its power to create provinces under Section 19, Article 6 of Republic Act 9054, enacted Muslim Mindanao Autonomy Act No. 201 creating the province of Sharif Kabun Suan composed of the 8 municipalities in the 1st District of Maguindanao. Muslim Mindanao Autonomy Act 201 provides. Section 1. The municipalities of Barriera, Buldan, Datuodan Sinsuat, Kabundalan, Matanog, Parang, Sultan Kudarat, Sultan Mastura, and Epi are hereby separated from the province of Maguindanao and constituted into a distinct and independent province, which is hereby created, to be known as the province of Sharif Kabun Suan. Content omitted X. Section 5. The corporate existence of this province shall commence upon the appointment by the regional governor or election of the governor and majority of the regular members of the Sangguniang Panlalawigan. The incumbent elective provincial officials of the province of Maguindanao shall continue to serve their unexpired terms in the province that they will choose or where they are residents, provided that where an elective position in both provinces becomes vacant as a consequence of the creation of the province of Sharif Kabun Suan, all incumbent elective provincial officials shall have preference for appointment to a higher elective vacant position and for the time being be appointed by the regional governor, and shall hold office until their successors shall have been elected and qualified in the next local elections, provided, further, that they shall continue to receive the salaries they are receiving at the time of the approval of this act until the new readjustment of salaries in accordance with law. Provided, furthermore, that there shall be no diminution in the number of the members of the Sangguniang Panlalawigan of the mother province, except as may be provided by national law. The existing legislative district, which includes Cotabato as a part thereof, shall remain. Later, 3 new municipalities were carved out of the original 9 municipalities constituting Sharif Kabun Suan, bringing its total number of municipalities to 11. Thus, what was left of Maguindanao were the municipalities constituting its second legislative district. Cotabato City, although part of Maguindanao's first legislative district, is not part of the province of Maguindanao. The voters of Maguindanao ratified Sharif Kabun Suan's creation in a plebiscite held on the 29th of October 2006. On the 6th of February 2007, the Sangguniang Panlungsod of Cotabato City passed Resolution No. 3999 requesting the COMELEC to clarify the status of Cotabato City in view of the conversion of the 1st District of Maguindanao into the regular province under Muslim Mindanao Autonomy Act 201. In answer to Cotabato City's query, the COMELEC issued Resolution No. 07-0407 on the 6th of March 2007 maintaining the status quo with Cotabato City as part of Sharif Kabun Suan in the 1st Legislative District of Maguindanao. Resolution No. 07-0407, which adopted the recommendation of the COMELEC's Law Department under a memorandum dated the 27th of February 2007, provides in pertinent parts. Considering the foregoing, the Commission resolved, as it hereby resolves, to adopt the recommendation of the Law Department that pending the enactment of the appropriate law by Congress, to maintain the status quo with Cotabato City as part of Sharif Kabunsuan in the 1st Legislative District of Maguindanao. However, in preparation for the 14th of May 2007 elections, the COMELEC promulgated on the 29th of March 2007 Resolution No. 7845 stating that Maguindanao's 1st Legislative District is composed only of Cotabato City because of the enactment of Muslim Mindanao Autonomy Act 201. On the 10th of May 2007, the COMELEC issued Resolution No. 7902, subject of these petitions, amending Resolution No. 07-0407 by renaming the legislative district in question as Sharif Kabunsuan Province with Cotabato City, formerly 1st District of Maguindanao with Cotabato City. In General Register No. 177,597, Sema, who was a candidate into the 14th of May 2007 elections for representative of Sharif Kabunsuan with Cotabato City, prayed for the nullification of COMELEC Resolution No. 7902 and the exclusion from canvassing of the votes cast in Cotabato City for that office. Sema contended that Sharif Kabunsuan is entitled to one representative in Congress under Section 5 Paragraph 3, Article 6 of the Constitution and Section 3 of the Ordinance appended to the Constitution. Thus, Sema asserted that the COMELEC acted without or in excess of its jurisdiction in issuing Resolution No. 7902 which maintained the status quo in Maguindanao's 1st Legislative District despite the COMELEC's earlier directive in Resolution No. 7845 designating Cotabato City as the lone component of Maguindanao's reapportioned 1st Legislative District. Sema further claimed that in issuing Resolution No. 7902, the COMELEC usurped Congress power to create or reapportion legislative districts. In its comment, the COMELEC, through the Office of the Solicitor General, chose not to reach the merits of the case and merely contended that, 1. Sema wrongly availed of the writ of certiorari to nullify COMELEC Resolution No. 7902 because the COMELEC issued the same in the exercise of its administrative, not quasi-judicial, power and, 2. Sema's prayer for the writ of prohibition in General Register No. 177,597 became moot with the proclamation of Respondent Didagen P. Dilangalen on 1 June 2007 as representative of the Legislative District of Sharif Kabunsuan Province with Cotabato City. In his comment, Respondent Dilangalen countered that Sema is stopped from questioning COMELEC Resolution No. 7902 because in her certificate of candidacy filed on 29 March 2007, Sema indicated that she was seeking election as representative of Sharif Kabunsuan including Cotabato City. Respondent Dilangalen added that COMELEC Resolution No. 7902 is constitutional because it did not apportion a legislative district for Sharif Kabunsuan or reapportion the legislative districts in Maguindanao but merely renamed Maguindanao's 1st Legislative District. Respondent Dilangalen further claimed that the COMELEC could not reapportion Maguindanao's 1st Legislative District to make Cotabato City its sole component unit as the power to reapportion legislative districts lies exclusively with Congress, not to mention that Cotabato City does not meet the minimum population requirement under Section 5 Paragraph 3, Article 6 of the Constitution for the creation of a legislative district within a city. Sema filed a consolidated reply controverting the matters raised in respondents' comments and reiterating her claim that the COMELEC acted ultra vires in issuing Resolution No. 7902. In the resolution of 4 September 2007, the court required the parties in General Register No. 177,597 to comment on the issue of whether a province created by the autonomous region in Muslim Mindanao Regional Assembly under Section 19, Article 6 of Republic Act 1954 is entitled to one representative in the House of Representatives without need of a national law creating a legislative district for such new province. The parties submitted their compliance as follows. 1. Sema answered the issue in the affirmative on the following grounds. A. The court in Felwa vs. Salas stated that when a province is created by statute, the corresponding representative district comes into existence neither by authority of that statute, which cannot provide otherwise, nor by apportionment, but by operation of the Constitution, without a reapportionment. B. Section 462 of Republic Act No. 7160 affirms the apportionment of a legislative district incident to the creation of a province, and C. Section 5 Paragraph 3, Article 6 of the Constitution and Section 3 of the Ordinance appended to the Constitution mandate the apportionment of a legislative district in newly created provinces. 2. The COMELEC, again represented by the Office of the Solicitor General, apparently abandoned its earlier stance on the propriety of issuing resolution numbers 07-0407 and 7902 and joined causes with Sema, contending that Section 5 Paragraph 3, Article 6 of the Constitution is self-executing. Thus, every new province created by the autonomous region in Muslim Mindanao Regional Assembly is ipso facto entitled to one representative in the House of Representatives even in the absence of a national law, and Paragraph 3 Respondent Dilangalen answered the issue in the negative on the following grounds. A. The province contemplated in Section 5 Paragraph 3, Article 6 of the Constitution is one that is created by an Act of Congress taking into account the provisions in Republic Act 7160 on the creation of provinces. B. Section 3, Article 4 of Republic Act 9054 withheld from the autonomous region in Muslim Mindanao Regional Assembly the power to enact measures relating to national elections, which encompasses the apportionment of legislative districts for members of the House of Representatives. C. Recognizing a legislative district in every province the autonomous region in Muslim Mindanao Regional Assembly creates will lead to the disproportionate representation of the autonomous region in Muslim Mindanao in the House of Representatives, as the Regional Assembly can create provinces without regard to the requirements in Section 461 of Republic Act 7160, and D. Cotabato City, which has a population of less than 250,000, is not entitled to a representative in the House of Representatives. On the 27th of November 2007, the court heard the parties in General Register number 177,597 in oral arguments on the following issues. 1. Whether Section 19, Article 6 of Republic Act 9054, delegating to the autonomous region in Muslim Mindanao Regional Assembly the power to create provinces, is constitutional, and 2. If in the affirmative, whether a province created under Section 19, Article 6 of Republic Act 9054 is entitled to one representative in the House of Representatives without need of a national law creating a legislative district for such new province. In compliance with the resolution dated the 27th of November 2007, the parties in General Register number 177,597 filed their respective memoranda on the issues raised in the oral arguments. On the question of the constitutionality of Section 19, Article 6 of Republic Act 9054, the parties in General Register number 177,597 adopted the following positions. 1. Sema contended that Section 19, Article 6 of Republic Act 9054 is constitutional, a. as a valid delegation by Congress to the autonomous region in Muslim Mindanao the power to create provinces under Section 29, Article 10 of the Constitution, granting to the autonomous regions, through their organic acts, legislative powers over other matters as may be authorized by law for the promotion of the general welfare of the people of the region, and b. as an amendment to Section 6 of Republic Act 7160. However, Sema concedes that, if taken literally, the grant in Section 19, Article 6 of Republic Act 9054 to the autonomous region in Muslim Mindanao Regional Assembly of the power to prescribe standards lower than those mandated in Republic Act 7160 in the creation of provinces contravenes Section 10, Article 10 of the Constitution. Thus, Sema proposed that Section 19 should be construed as prohibiting the Regional Assembly from prescribing standards content omitted that do not comply with the minimum criteria under Republic Act 7160. 2. Respondent Dilangalen contended that Section 19, Article 6 of Republic Act 9054 is unconstitutional on the following grounds. A. The power to create provinces was not among those granted to the autonomous regions under Section 20, Article 10 of the Constitution, and b. The grant under Section 19, Article 6 of Republic Act 9054 to the autonomous region in Muslim Mindanao Regional Assembly of the power to prescribe standards lower than those mandated in Section 461 of Republic Act 7160 on the creation of provinces contravenes Section 10, Article 10 of the Constitution and the Equal Protection Clause, and 3. The COMELEC, through the Office of the Solicitor General, joined causes with Respondent Dilangalen, thus effectively abandoning the position the COMELEC adopted in its compliance with the resolution of 4 September 2007, and contended that Section 19, Article 6 of Republic Act 9054 is unconstitutional because, a. it contravenes Section 10 and Section 6, Article 10 of the Constitution, and b. the power to create provinces was withheld from the autonomous regions under Section 20, Article 10 of the Constitution. On the question of whether a province created under Section 19, Article 6 of Republic Act 1954 is entitled to one representative in the House of Representatives without need of a national law creating a legislative district for such new province. Sema and Respondent Dilangalen reiterated in their memoranda the positions they adopted in their compliance with the resolution of 4 September 2007. The COMELEC deemed it unnecessary to submit its position on this issue considering its stance that Section 19, Article 6 of Republic Act 1954 is unconstitutional. The pendency of the petition in General Register, number 178628 was disclosed during the oral arguments on the 27th of November 2007. Thus, in the resolution of the 19th of February 2008, the court ordered General Register, number 178628 consolidated with General Register, number 177597. The petition in General Register, number 178628 echoed Sema's contention that the COMELEC acted ultra vires in issuing Resolution number 7902 depriving the voters of Cotabato City of a representative in the House of Representatives. In its comment to the petition in General Register, number 178628, the COMELEC, through the Office of the Solicitor General, maintained the validity of COMELEC Resolution number 7902 as a temporary measure pending the enactment by Congress of the appropriate law. The issues. The petitions raise the following issues. I. In General Register, number 177597, A. Preliminarily - 1. Whether the writs of certiorari, prohibition, and mandamus are proper to test the constitutionality of COMELEC Resolution number 7902, and 2. Whether the proclamation of Respondent Dilangalen as representative of Sharif Kabunsuan Province with Cotabato City mooted the petition in General Register, number 177597. B. On the merits - 1. Whether Section 19, Article 6 of Republic Act 1954, delegating to the autonomous region in Muslim Mindanao Regional Assembly the power to create provinces, cities, municipalities and barangays, is constitutional, and 2. If in the affirmative, whether a province created by the autonomous region in Muslim Mindanao Regional Assembly under Muslim Mindanao Autonomy Act 201 pursuant to Section 19, Article 6 of Republic Act 1954 is entitled to one representative in the House of Representatives without need of a national law creating a legislative district for such province. 2. In General Register, number 177597 and General Register, number 178628, whether COMELEC Resolution number 7902 is valid for maintaining the status quo in the first legislative district of Maguindanao, as Sharif Kabunsuan Province with Cotabato City, formerly 1st District of Maguindanao with Cotabato City, despite the creation of the province of Sharif Kabunsuan out of such district, excluding Cotabato City. The ruling of the court. The petitions have no merit. We rule that 1. Section 19, Article 6 of Republic Act 1954 is unconstitutional insofar as it grants to the autonomous region in Muslim Mindanao Regional Assembly the power to create provinces and cities. 2. Muslim Mindanao Autonomy Act 201 creating the province of Sharif Kabunsuan is void, and 3. COMELEC Resolution number 7902 is valid. On the preliminary matters, the writ of prohibition is appropriate to test the constitutionality of election laws, rules and regulations. The purpose of the writ of certiorari is to correct grave abuse of discretion by any tribunal, board, or officer exercising judicial or quasi-judicial functions. On the other hand, the writ of mandamus will issue to compel a tribunal, corporation, board, officer, or person to perform an act which the law specifically enjoins as a duty. True, the COMELEC did not issue Resolution number 7902 in the exercise of its judicial or quasi-judicial functions. Nor is there a law which specifically enjoins the COMELEC to exclude from canvassing the votes cast in Cotabato City for representative of Sharif Kabunsuan Province with Cotabato City. These, however, do not justify the outright dismissal of the petition in General Register, number 177597 because Sema also prayed for the issuance of the writ of prohibition and we have long recognized this writ as proper for testing the constitutionality of election laws, rules, and regulations. Respondent Dilangalen's proclamation does not moot the petition. There is also no merit in the claim that Respondent Dilangalen's proclamation as winner in the 14th of May 2007 elections for representative of Sharif Kabunsuan province with Cotabato City mooted this petition. This case does not concern Respondent Dilangalen's election. Rather, it involves an inquiry into the validity of COMELEC Resolution No. 7902, as well as the constitutionality of Muslim Mindanao Autonomy Act 201 and Section 19, Article 6 of Republic Act 1954. Admittedly, the outcome of this petition, one way or another, determines whether the votes cast in Cotabato City for representative of the district of Sharif Kabunsuan province with Cotabato City will be included in the canvassing of ballots. However, this incidental consequence is no reason for us not to proceed with the resolution of the novel issues raised here. The court's ruling in these petitions affects not only the recently concluded elections but also all the other succeeding elections for the office in question, as well as the power of the autonomous region in Muslim Mindanao Regional Assembly to create in the future additional provinces. On the main issues, whether the autonomous region in Muslim Mindanao Regional Assembly can create the province of Sharif Kabunsuan, the creation of local government units is governed by Section 10, Article 10 of the Constitution, which provides, Section 10. No province, city, municipality, or barangay may be created, divided, merged, abolished or its boundary substantially altered except in accordance with the criteria established in the local government code and subject to approval by a majority of the votes cast in a plebiscite in the political units directly affected. Thus, the creation of any of the four local government units, province, city, municipality or barangay, must comply with three conditions. First, the creation of a local government unit must follow the criteria fixed in the local government code. Second, such creation must not conflict with any provision of the Constitution. Third, there must be a plebiscite in the political units affected. There is neither an express prohibition nor an express grant of authority in the Constitution for Congress to delegate to regional or local legislative bodies the power to create local government units. However, under its plenary legislative powers, Congress can delegate to local legislative bodies the power to create local government units, subject to reasonable standards and provided no conflict arises with any provision of the Constitution. In fact, Congress has delegated to provincial boards, and city and municipal councils, the power to create barangays within their jurisdiction, subject to compliance with the criteria established in the local government code, and the plebiscite requirement in Section 10, Article 10 of the Constitution. However, under the local government code, only content-emitted an act of Congress can create provinces, cities or municipalities. Under Section 19, Article 6 of Republic Act 1954, Congress delegated to the autonomous region in Muslim Mindanao Regional Assembly the power to create provinces, cities, municipalities and barangays within the autonomous region in Muslim Mindanao. Congress made the delegation under its plenary legislative powers because the power to create local government units is not one of the express legislative powers granted by the Constitution to regional legislative bodies. In the present case, the question arises whether the delegation to the autonomous region in Muslim Mindanao Regional Assembly of the power to create provinces, cities, municipalities and barangays conflicts with any provision of the Constitution. There is no provision in the Constitution that conflicts with the delegation to regional legislative bodies of the power to create municipalities and barangays, provided Section 10, Article 10 of the Constitution is followed. However, the creation of provinces and cities is another matter. Section 5 Paragraph 3, Article 6 of the Constitution provides, each city with a population of at least 250,000, or each province, shall have at least one representative in the House of Representatives. Similarly, Section 3 of the ordinance appended to the Constitution provides, any province that may hereafter be created, or any city whose population may hereafter increase to more than 250,000 shall be entitled in the immediately following election to at least one member content omitted. Clearly, a province cannot be created without a legislative district because it will violate Section 5 Paragraph 3, Article 6 of the Constitution as well as Section 3 of the ordinance appended to the Constitution. For the same reason, a city with a population of 250,000 or more cannot also be created without a legislative district. Thus, the power to create a province, or a city with a population of 250,000 or more, requires also the power to create a legislative district. Even the creation of a city with a population of less than 250,000 involves the power to create a legislative district, because once the city's population reaches 250,000, the city automatically becomes entitled to one representative under Section 5 Paragraph 3, Article 6 of the Constitution and Section 3 of the Ordinance appended to the Constitution. Thus, the power to create a province or city inherently involves the power to create a legislative district. For Congress to delegate validly the power to create a province or city, it must also validly delegate at the same time the power to create a legislative district. The threshold issue then is, can Congress validly delegate to the autonomous region in Muslim Mindanao Regional Assembly the power to create legislative districts for the House of Representatives? The answer is in the negative. Legislative districts are created or reapportioned only by an act of Congress. Under the present Constitution, as well as in past constitutions, the power to increase the allowable membership in the House of Representatives, and to reapportion legislative districts, is vested exclusively in Congress. Section 5, Article 6 of the Constitution provides. Section 5. 1. The House of Representatives shall be composed of not more than 250 members, unless otherwise fixed by law, who shall be elected from legislative districts apportioned among the provinces, cities, and the metropolitan Manila area in accordance with the number of their respective inhabitants, and on the basis of a uniform and progressive ratio, and those who, as provided by law, shall be elected through a party list system of registered national, regional, and sectoral parties or organizations. Content omitted X. 3. Each legislative district shall comprise, as far as practicable, contiguous, compact, and adjacent territory. Each city with a population of at least 250,000, or each province, shall have at least one representative. 4. Within 3 years following the return of every census, the Congress shall make a reapportionment of legislative districts based on the standards provided in this section. Section 5 Paragraph 1, Article 6 of the Constitution vests in Congress the power to increase, through a law, the allowable membership in the House of Representatives. Section 5 Paragraph 4 empowers Congress to reapportion legislative districts. The power to reapportion legislative districts necessarily includes the power to create legislative districts out of existing ones. Congress exercises these powers through a law that Congress itself enacts, and not through a law that regional or local legislative bodies enact. The allowable membership of the House of Representatives can be increased, and new legislative districts of Congress can be created, only through a national law passed by Congress. In Monte vs. COMELEC, we held that the power of redistricting content omitted is traditionally regarded as part of the power of Congress to make laws, and thus is vested exclusively in Congress. This textual commitment to Congress of the exclusive power to create or reapportion legislative districts is logical. Congress is a national legislature, and any increase in its allowable membership or in its incumbent membership through the creation of legislative districts must be embodied in a national law. Only Congress can enact such a law. It would be anomalous for regional or local legislative bodies to create or reapportion legislative districts for a national legislature like Congress. An inferior legislative body, created by a superior legislative body, cannot change the membership of the superior legislative body. The creation of the autonomous region in Muslim Mindanao, and the grant of legislative powers to its regional assembly under its Organic Act, did not divest Congress of its exclusive authority to create legislative districts. This is clear from the Constitution and the Autonomous Region in Muslim Mindanao Organic Act, as amended. Thus, Section 20, Article 10 of the Constitution provides. Section 20. Within its territorial jurisdiction and subject to the provisions of this Constitution and national laws, the Organic Act of Autonomous Regions shall provide for legislative powers over 1. Administrative organization. 2. Creation of sources of revenues. 3. Ancestral domain and natural resources. 4. Personal, family, and property relations. 5. Regional urban and rural planning development. 6. Economic, social, and tourism development. 7. Educational policies. 8. Preservation and development of the cultural heritage, and 9. Such other matters as may be authorized by law for the promotion of the general welfare of the people of the region. Nothing in Section 20, Article 10 of the Constitution authorizes autonomous regions, expressly or impliedly, to create or reapportion legislative districts for Congress. On the other hand, Section 3, Article 4 of Republic Act 1954 amending the Autonomous Region in Muslim Mindanao Organic Act, provides, the Regional Assembly may exercise legislative power content omitted except on the following matters, content omitted. K. National elections. Content omitted. Since the Autonomous Region in Muslim Mindanao Regional Assembly has no legislative power to enact laws relating to national elections, it cannot create a legislative district whose representative is elected in national elections. Whenever Congress enacts a law creating a legislative district, the first representative is always elected in the next national elections from the effectivity of the law. Indeed, the office of a legislative district representative to Congress is a national office, and its occupant, a member of the House of Representatives, is a national official. It would be incongruous for a regional legislative body like the Autonomous Region in Muslim Mindanao Regional Assembly to create a national office when its legislative powers extend only to its regional territory. The office of a district representative is maintained by national funds and the salary of its occupant is paid out of national funds. It is a self-evident inherent limitation on the legislative powers of every local or regional legislative body that it can only create local or regional offices, respectively, and it can never create a national office. To allow the Autonomous Region in Muslim Mindanao Regional Assembly to create a national office is to allow its legislative powers to operate outside the Autonomous Region in Muslim Mindanao's territorial jurisdiction. This violates Section 20, Article 10 of the Constitution, which expressly limits the coverage of the Regional Assembly's legislative powers within its territorial jurisdiction. Content omitted. The Autonomous Region in Muslim Mindanao Regional Assembly itself, in creating Sharif Kabunsuan, recognized the exclusive nature of Congress power to create or reapportion legislative districts by abstaining from creating a legislative district for Sharif Kabunsuan. Section 5 of Muslim Mindanao Autonomy Act 201 provides that, except as may be provided by national law, the existing legislative district, which includes Cotabato City as a part thereof, shall remain. Emphasis applied. However, a province cannot legally be created without a legislative district because the Constitution mandates that each province shall have at least one representative. Thus, the creation of the province of Sharif Kabunsuan without a legislative district is unconstitutional. Sema, Petitioner in General Register, Number 177,597, contends that Section 5 Paragraph 3, Article 6 of the Constitution, which provides, each legislative district shall comprise, as far as practicable, contiguous, compact, and adjacent territory. Each city with a population of at least 250,000, or each province, shall have at least one representative. And Section 3 of the ordinance appended to the Constitution, which states, any province that may hereafter be created, or any city whose population may hereafter increase to more than 250,000 shall be entitled in the immediately following election to at least one member or such number of members as it may be entitled to on the basis of the number of its inhabitants and according to the standards set forth in Paragraph 3, Section 5 of Article 6 of the Constitution. The number of members apportioned to the province out of which such new province was created or where the city, whose population has so increased, is geographically located shall be correspondingly adjusted by the Commission on Elections, but such adjustment shall not be made within 120 days before the election. Emphasis applied. Serve as basis for the conclusion that the province of Sharif Kabunsuan, created on the 29th of October 2006, is automatically entitled to one member in the House of Representatives in the 14th of May 2007 elections. As further support for her stance, Petitioner invokes the statement in Felwa that when a province is created by statute, the corresponding representative district comes into existence neither by authority of that statute, which cannot provide otherwise, nor by apportionment, but by operation of the Constitution, without a reapportionment. The contention has no merit. First, the issue in Felwa, among others, was whether Republic Act 4695, creating the provinces of Benguet, Mountain Province, Ifugao, and Kalinga-Apayao and providing for congressional representation in the old and new provinces, was unconstitutional for creating congressional districts without the apportionment provided in the Constitution. The court answered in the negative. Thus, the Constitution ordains, the House of Representatives shall be composed of not more than 120 members who shall be apportioned among the several provinces as nearly as may be according to the number of their respective inhabitants, but each province shall have at least one member. The Congress shall by law make an apportionment within 3 years after the return of every enumeration, and not otherwise. Until such apportionment shall have been made, the House of Representatives shall have the same number of members as that fixed by law for the National Assembly, who shall be elected by the qualified electors from the present Assembly districts. Each representative district shall comprise, as far as practicable, contiguous and compact territory. Pursuant to this section, a representative district may come into existence, a. indirectly, through the creation of a province, for each province shall have at least one member in the House of Representatives, or, b. by direct creation of several representative districts within a province. The requirements concerning the apportionment of representative districts and the territory thereof refer only to the second method of creation of representative districts, and do not apply to those incidental to the creation of provinces, under the first method. This is deducible, not only from the general tenor of the provision above quoted, but, also, from the fact that the apportionment therein alluded to refers to that which is made by an act of Congress. Indeed, when a province is created by statute, the corresponding representative district comes into existence neither by authority of that statute, which cannot provide otherwise, nor by apportionment, but by operation of the Constitution, without a reapportionment. There is no constitutional limitation as to the time when, territory of, or other conditions under which a province may be created, except, perhaps, if the consequence thereof were to exceed the maximum of 120 representative districts prescribed in the Constitution, which is not the effect of the legislation under consideration. As a matter of fact, provinces have been created or subdivided into other provinces, with the consequent creation of additional representative districts, without complying with the aforementioned requirements. Thus, the Court sustained the constitutionality of Republic Act 4695 because, 1. It validly created legislative districts indirectly through a special law enacted by Congress creating a province, and, 2. The creation of the legislative districts will not result in breaching the maximum number of legislative districts provided under the 1935 Constitution. Felwa does not apply to the present case because in Felwa the new provinces were created by a national law enacted by Congress itself. Here, the new province was created merely by a regional law enacted by the autonomous region in Muslim Mindanao Regional Assembly. What Felwa teaches is that the creation of a legislative district by Congress does not emanate alone from Congress power to reapportion legislative districts, but also from Congress power to create provinces which cannot be created without a legislative district. Thus, when a province is created, a legislative district is created by operation of the Constitution because the Constitution provides that each province shall have at least one representative in the House of Representatives. This does not detract from the constitutional principle that the power to create legislative districts belongs exclusively to Congress. It merely prevents any other legislative body, except Congress, from creating provinces because for a legislative body to create a province such legislative body must have the power to create legislative districts. In short, only an act of Congress can trigger the creation of a legislative district by operation of the Constitution. Thus, only Congress has the power to create, or trigger the creation of, a legislative district. Moreover, if as Sema claims Muslim Mindanao Autonomy Act 201 apportioned a legislative district to Sharif Kabunsuan upon its creation, this will leave Cotabato City as the lone component of the first legislative district of Maguindanao. However, Cotabato City cannot constitute a legislative district by itself because as of the census taken in 2000, it had a population of only 163,849. To constitute Cotabato City alone as the surviving first legislative district of Maguindanao will violate Section 5 Paragraph 3, Article 6 of the Constitution, which requires that each city with a population of at least 250,000 content omitted, shall have at least one representative. Second, Sema's theory also undermines the composition and independence of the House of Representatives. Under Section 19, Article 6 of Republic Act 1954, the autonomous region in Muslim Mindanao Regional Assembly can create provinces and cities within the autonomous region in Muslim Mindanao with or without regard to the criteria fixed in Section 461 of Republic Act 7160, namely, minimum annual income of 20 million pesos, and minimum contiguous territory of 2,000 square kilometers or minimum population of 250,000. The following scenarios thus become distinct possibilities. 1. an inferior legislative body like the Autonomous Region in Muslim Mindanao Regional Assembly can create 100 or more provinces and thus increase the membership of a superior legislative body, the House of Representatives, beyond the maximum limit of 250 fixed in the Constitution, unless a national law provides otherwise. 2. The proportional representation in the House of Representatives based on one representative for at least every 250,000 residents will be negated because the Autonomous Region in Muslim Mindanao Regional Assembly need not comply with the requirement in Section 461A, 2, of Republic Act 7160 that every province created must have a population of at least 250,000, and 3. Representatives from the Autonomous Region in Muslim Mindanao provinces can become the majority in the House of Representatives through the Autonomous Region in Muslim Mindanao Regional Assembly's continuous creation of provinces or cities within the Autonomous Region in Muslim Mindanao. The following exchange during the oral arguments of the petition in General Register, Number 177,597 highlights the absurdity of Sema's position that the Autonomous Region in Muslim Mindanao Regional Assembly can create provinces. Justice Carpio: so, you mean to say a local government can create legislative districts and pack Congress with their own representatives? Attorney Vistan II: yes, Your Honor, because the Constitution allows that. Justice Carpio: so, the Regional Assembly of the Autonomous Region in Muslim Mindanao can create content-omitted provinces content-omitted and, therefore, they can have 35 new representatives in the House of Representatives without Congress agreeing to it. Is that what you are saying? That can be done, under your theory? Attorney Vistan II: yes, Your Honor, under the correct factual circumstances. Justice Carpio: under your theory, the Autonomous Region in Muslim Mindanao legislature can create 35 new provinces. There may be content omitted, only 100,000, population, content omitted, and they will each have one representative content omitted to Congress without any national law. Is that what you are saying? Attorney Vistan II: without law passed by Congress, yes, Your Honor, that is what we are saying. Content omitted X. Justice Carpio: so, they can also create 1,000 new provinces, send 1,000 representatives to the House of Representatives without a national law. That is legally possible, correct? Attorney Vistan II: yes, Your Honor. Neither the framers of the 1987 Constitution in adopting the provisions in Article 10 on regional autonomy, nor Congress in enacting Republic Act 9054, envisioned or intended these disastrous consequences that certainly would wreck the tri-branch system of government under our Constitution. Clearly, the power to create or reapportion legislative districts cannot be delegated by Congress but must be exercised by Congress itself. Even the Autonomous Region in Muslim Mindanao Regional Assembly recognizes this. The Constitution empowered Congress to create or reapportion legislative districts, not the regional assemblies. Section 3 of the Ordinance to the Constitution, which states, any province that may hereafter be created content omitted shall be entitled in the immediately following election to at least one member, refers to a province created by Congress itself through a national law. The reason is that the creation of a province increases the actual membership of the House of Representatives, an increase that only Congress can decide. Incidentally, in the present 14th Congress, there are 219 district representatives out of the maximum 250 seats in the House of Representatives. Since party list members shall constitute 20% of total membership of the House, there should at least be 50 party list seats available in every election in case 50 party list candidates are proclaimed winners. This leaves only 200 seats for district representatives, much less than the 219 incumbent district representatives. Thus, there is a need now for Congress to increase by law the allowable membership of the House, even before Congress can create new provinces. It is axiomatic that organic acts of autonomous regions cannot prevail over the Constitution. Section 20, Article 10 of the Constitution expressly provides that the legislative powers of regional assemblies are limited within its territorial jurisdiction and subject to the provisions of the Constitution and national laws, content omitted. The preamble of the Autonomous Region in Muslim Mindanao Organic Act, Republic Act 9054, itself states that the Autonomous Region in Muslim Mindanao government is established within the framework of the Constitution. This follows Section 15, Article 10 of the Constitution, which mandates that the autonomous region in Muslim Mindanao shall be created, content omitted within the framework of this Constitution, and the national sovereignty as well as territorial integrity of the Republic of the Philippines. The present case involves the creation of a local government unit that necessarily involves also the creation of a legislative district. The court will not pass upon the constitutionality of the creation of municipalities and barangays that does not comply with the criteria established in Section 461 of Republic Act 7160, as mandated in Section 10, Article 10 of the Constitution, because the creation of such municipalities and barangays does not involve the creation of legislative districts. We leave the resolution of this issue to an appropriate case. In summary, we rule that Section 19, Article 6 of Republic Act 1954, insofar as it grants to the autonomous region in Muslim Mindanao Regional Assembly the power to create provinces and cities, is void for being contrary to Section 5 of Article 6 and Section 20 of Article 10 of the Constitution, as well as Section 3 of the Ordinance appended to the Constitution. Only Congress can create provinces and cities because the creation of provinces and cities necessarily includes the creation of legislative districts, a power only Congress can exercise under Section 5, Article 6 of the Constitution and Section 3 of the Ordinance appended to the Constitution. The autonomous region in Muslim Mindanao Regional Assembly cannot create a province without a legislative district because the Constitution mandates that every province shall have a legislative district. Moreover, the autonomous region in Muslim Mindanao Regional Assembly cannot enact a law creating a national office like the office of a district representative of Congress because the legislative powers of the autonomous region in Muslim Mindanao Regional Assembly operate only within its territorial jurisdiction as provided in Section 20, Article 10 of the Constitution. Thus, we rule that Muslim Mindanao Autonomy Act 201, enacted by the autonomous region in Muslim Mindanao Regional Assembly and creating the province of Sharif Kabunsuan, is void. Resolution number 7902 complies with the Constitution. Consequently, we hold that COMELEC Resolution number 7902, preserving the geographic and legislative district of the 1st District of Maguindanao with Cotabato City, is valid as it merely complies with Section 5 of Article 6 and Section 20 of Article 10 of the Constitution, as well as Section 1 of the Ordinance appended to the Constitution. Wherefore, we declare Section 19, Article 6 of Republic Act No. 1954 unconstitutional insofar as it grants to the Regional Assembly of the Autonomous Region in Muslim Mindanao the power to create provinces and cities. Thus, we declare void Muslim Mindanao Autonomy Act No. 201 creating the province of Sharif Kabunsuan. Consequently, we rule that COMELEC Resolution No. 7902 is valid. Let a copy of this ruling be served on the President of the Senate and the Speaker of the House of Representatives. So ordered.